The penalty for stealing from an estate can be as simple as returning the stolen money or assets, with the possibility of treble damages, double damages, punitive damages, disinheritance, attorney's fees, and/or costs. Because these issues are civil and not criminal in nature, however, generally the authorities do not get involved and criminal charges are not filed. What is the penalty for stealing from an estate? When an abuser steals from an estate, the penalty can be as little as simply returning the stolen money or property to the estate. However, the California Probate Code does provide statutory bases for pursuing double damages, which just means 2 times whatever was taken, treble damages, which means 3 times whatever was taken, punitive damages, which means damages to punish the wrongdoer, disinheritance of the abuser, attorney's fees, and/or costs in egregious cases. The availability and likelihood of these remedies and recoveries is very fact determinative and should be discussed with a probate or estate litigation attorney as early as possible, as soon as you suspect wrongdoing. How do I get money and assets returned? In most situations, we've been able to recover monies and assets stolen from an estate or trust swiftly using the following litigation tools or pre-litigation tools. Early, thorough due diligence of our client's case, including informal discovery and witness development. Second, preparation of a formal complaint or petition filed with the probate court. Third, early discussion with opposing counsel or parties about informal or formal resolution processes. Fourth, early discovery of additional documents and information to fill in the gaps discovered during the due diligence process and/or pointed out by our opposition. Fifth, utilizing formal court resolution processes, and, if those are unsuccessful, sixth, being prepared to set the case for trial and trying that case as soon as possible. Civil court versus criminal court. Stealing from an estate or trust is a civil matter, which means that the authorities most likely aren't going to do anything other than make a police report about the theft. It's highly unlikely, unless the theft is such monumental and institutional nature, that a district attorney will have the time or resources to make an individual case a priority for prosecution. What this means, and it's often very frustrating for families, is that the wrongs committed against the estate or trust will only be addressed in civil court, here the probate court, where the damages available will include those that we've highlighted previously. But the bottom line is that usually, in almost every case, nobody's going to jail. When does stealing from an estate become criminal? Stealing from an estate rarely escalates to criminal charges, in our experience. And it won't become a matter for the criminal courts unless a criminal charge is filed with the authorities. This requires the victim to go through the process of filing the charge, meaning there must be a clear desire of the victim to proceed to criminal processes. Typically, family members don't want to charge other family members or trusted family friends with criminal charges and the risk of jail time. How do I prove if someone is stealing from an estate? If you feel that a trustee, an executor, a caregiver, friend, family member, or anybody else is stealing from an estate or trust, you need to contact an estate or trust litigation attorney immediately. There are time limits to when a case can be brought, and if you sleep on your claims, they'll most likely be lost. A trust litigation attorney can help you understand your claims and advise you as to when you need to file them so they're not lost. When do I contact an estate attorney? Contact an estate attorney the moment you begin to suspect funds or assets are being misappropriated from an estate. In most cases, most attorneys will provide a free consultation. How much does an estate litigation attorney cost? It's a common question, and although an unpopular answer, the correct one is that it depends. The relative complexity of your case, the number of parties and claims involved, the passage of time, assets involved, etc., all mean that the case is likely to cost more. The relative resistance anticipated from the other party to be sued can also mean higher costs. It's really something that should be discussed with your attorney from the first go. Fortunately, a good trust litigation attorney will be able to help you understand the value of your case and should be able to help you structure a financial arrangement that makes sense for you and the firm. Don't let your fear that you can't afford it stop you from pursuing a claim. There are many ways to structure an engagement. Just ask. Do I need an estate litigation attorney near me? We recommend finding an experienced estate or trust litigation attorney familiar with the county probate court in the county where the action is going to take place. For example, if the victim lives in San Diego, yet the trust is based in Los Angeles, we recommend working with a trust litigation lawyer in Los Angeles. A Los Angeles trust litigation lawyer will generally be more familiar with the Los Angeles probate courts than someone from out of state. At RMO, we protect people like you every day. Call or email us with questions. We're always happy to help. Thanks for watching.